So Donald Trump's legal team was just physically removed from a federal courtroom after what witnesses are describing as one of the most explosive attorney meltdowns ever seen in a major trial. And what caused this total collapse? Prosecutors introduced a single email that Trump's lawyers had previously sworn under oath did not exist. We're talking about defense attorneys being escorted out by federal marshals while one of them was literally yelling at the judge, calling the proceeding a kangaroo court. This is not just another heated moment in Trump's long list of legal battles. These are licensed attorneys risking disbarment, contempt citations, and even potential criminal exposure by unraveling so badly that a federal judge had no option but to remove them from the courtroom. And when federal marshals are walking lawyers out while the judge threatens bar referrals, you know something completely unprecedented just happened. It is honestly shocking to watch officers of the court, people who survived years of law school and passed the bar, lose professional control so completely that legal experts are already saying this could end their careers. Here's how things reached this point. Trump's legal strategy throughout the trial depended heavily on his lawyers' credibility with the court. His defense team argued that any document retention issues were accidental, that Trump relied on legal advice, and that prosecutors were engaging in politically motivated selective enforcement. For weeks, they maintained a polished courtroom presence, followed procedure, and positioned themselves as serious attorneys pushing back against government overreach. According to December 10th reporting from Politico, the defense had successfully raised doubts about parts of the government's timeline and forced several prosecution witnesses to admit ambiguity in email chains and document handling. The approach was effective enough that some legal analysts suggested Trump might actually establish reasonable doubt on certain charges. But this is where everything collapsed. Prosecutors had been laying the foundation for a specific piece of evidence for days. They built it through testimony about document retention policies, reinforced timelines with phone records, and framed a narrative of intentional obstruction rather than simple carelessness. Then, on the morning of December 10th, prosecutors informed the judge they intended to introduce a newly authenticated email that had been part of a broader document production but had not yet been shown to the jury. And let's be honest for a moment. When prosecutors say they have one final piece of evidence and the defense starts objecting before even seeing it, something is about to go very wrong. Here's where it gets intense. According to reporters from CBS News, CNN, and Associated Press who were inside the courtroom, the prosecution distributed copies of the email simultaneously to the judge, the jury, and the defense. The email was dated August 2022, right in the middle of negotiations between Trump's lawyers and the Justice Department over the return of classified materials. Seconds after reading it, Trump's lead trial attorney stood up and demanded an immediate sidebar. The judge granted the request and called all counsel to the bench for what was supposed to be a quiet discussion outside the jury's hearing. That is when everything unraveled. According to CNN's legal correspondent, Trump's attorney raised his voice almost instantly, accusing the government of fabricating evidence. The judge warned him to lower his voice. Instead, he got louder and demanded the court declare a mistrial on the spot. The judge immediately called a recess and removed the jury from the room. Once proceedings resumed on the record without the jury present, the situation exploded. Speaking directly into the microphone, Trump's lead counsel accused prosecutors of withholding exculpatory evidence, manufacturing documents, and committing misconduct that he claimed amounted to criminal fraud on the court. When the judge asked him to explain exactly what he was alleging, he made the statement that sealed his fate. He declared that his team had thoroughly reviewed all emails from that time period, and that the specific email just introduced did not exist in any of the productions they received. He insisted they had never seen it before that moment. Then the prosecutor calmly stood up and dropped the bombshell. She informed the court that the email had been produced to the defense during the third document production in September, that it was clearly listed in the production index as item number 4732, and that the defense had actually cited the same email thread in one of their own pretrial motions, conveniently omitting the most damaging portion. She then handed the judge a copy of the defense's own filing with the email thread number highlighted, proving the defense not only received it, but used it. According to reporters in the room, the atmosphere turned electric. Trump's attorney's face reportedly flushed bright red. Instead of backing off or asking to confer with his team, he doubled down. He accused the prosecutor of lying, claimed the email was altered after production, and insisted it was all a setup. The judge, clearly losing patience, asked whether he was accusing the government of fabricating federal evidence. The attorney replied yes, explicitly stating that was his allegation. At that point, Trump's second-chair attorney attempted to pull him back toward the defense table, physically tugging at his sleeve. The lead counsel brushed him off and continued, claiming the prosecution should be investigated, calling the situation worse than Watergate, and accusing the judge of complicity If the email was shown to the jury, that was enough. In a voice reporters described as tightly controlled, the judge informed him he was in contempt of court and ordered him to sit down immediately or be removed. Instead, the attorney declared he would not be silenced, said he was willing to go to jail to expose what was happening, and claimed he was defending his client's constitutional rights. The judge then turned to the federal marshals and said one word: remove him. As two marshals approached, the second attorney stood up and began shouting that this violated Trump's Sixth Amendment right to counsel and proved the system was rigged. The judge raised her hand, pointed at him, and said, "Him too." Both attorneys were escorted out of the courtroom, while one shouted back that it was a kangaroo court and that the truth would come out. The remaining junior attorney sat motionless at the defense table, visibly stunned by what had just occurred. This is not the first time Trump's lawyers have destroyed their professional reputations defending him. Think about Rudy Giuliani, who went from being celebrated as America's mayor to a disbarred attorney facing bankruptcy after spreading false election fraud claims for Trump. Giuliani lost his law licenses in New York and Washington, faced a $148 million defamation judgment, and obliterated a decades-long career. Then there was Sidney Powell, whose extreme claims about voting machines led to defamation lawsuits, criminal exposure in Georgia, and complete professional humiliation within the legal community. Powell went from being a respected federal prosecutor to a figure whose name became associated with conspiracy theories and unsupported claims. And we cannot ignore Jenna Ellis, who pleaded guilty in the Georgia case and was forced to publicly admit she made false statements about the 2020 election. Ellis was disciplined by the Colorado bar, acknowledged she relied on information from others without verifying facts, and effectively admitted that representing Trump led her to violate her professional duties. Then there is John Eastman, the attorney behind the memo claiming Mike Pence could refuse to certify electoral votes. Eastman is now facing disbarment proceedings in California and potential criminal exposure elsewhere. His legal career has been dismantled because he advanced a theory that virtually every serious constitutional scholar said had no legal foundation. Now it appears Trump's current trial attorneys are joining this growing list of lawyers who believed they could bend ethical rules, make extreme claims, and escape consequences as long as they were doing it for Trump. The pattern is unmistakable. Every lawyer who fully commits to defending Trump by crossing professional boundaries ends up professionally ruined. So what exactly did these attorneys do that was so far beyond acceptable conduct that immediate removal from the courtroom became unavoidable? It comes down to making a factual claim to the court that was provably false and then refusing to retreat once confronted with proof. Legal ethics experts explained to multiple outlets that attorneys owe a duty of candor to the court. That means you cannot knowingly present false information to a judge. When Trump's lead attorney stated that his team had never received the email, he made a direct factual assertion on the record. When the prosecutor immediately demonstrated that the claim was false by pointing to production logs and the defense's own motion, referencing that email thread, the attorney had a professional obligation to acknowledge the mistake, correct the record, and move on. Instead, he escalated. He accused the prosecution of fabricating evidence. That accusation alone is extraordinarily serious and requires concrete proof, not emotional deflection. Here is the critical moment. The judge asked him directly whether he was formally accusing the government of manufacturing evidence, offering him a clear opportunity to walk the statement back. He said yes. According to legal analysts, that was the point of no return. Competent attorneys do not accuse prosecutors of criminal misconduct without overwhelming evidence, especially when the record clearly shows their own statement was inaccurate. The judge then issued a direct order for him to sit down and stop speaking. That was another chance to halt the spiral. He refused. At that point, removal was not optional. It was required. A judge cannot allow an attorney to disrupt proceedings, defy court orders, and make demonstrably false claims. A courtroom can only function if basic professional standards are enforced. Experts also noted that the second attorney sealed his own fate by standing up and shouting as well. Once a judge orders someone removed and you choose to join the disruption, you are effectively volunteering to be removed too. This leaves Trump in an extremely precarious position. On one hand, he must now continue a complex federal trial with only a junior attorney who was never prepared to serve as lead counsel. That lawyer is suddenly responsible for managing the remainder of the case, conducting cross-examinations, making legal arguments, and protecting Trump's interests without the preparation and strategy developed by the now removed attorneys. That is nearly impossible in a trial of this magnitude. On the other hand, Trump's entire defense strategy just collapsed in the most public and damaging way imaginable. His lawyers did not merely lose an argument, they were expelled from court for making false claims and losing control. That image is now burned into the minds of the jury. The signal it sends is devastating. It suggests the defense was so weak and so indefensible that the attorneys imploded rather than confront the evidence, and there is no way to erase that impression. Trump is now trapped. He can attempt to bring in new attorneys mid-trial, which would require requesting a continuance the judge is highly unlikely to grant. Even if it were granted, the jury would see that his original legal team collapsed so completely that they had to be replaced. That inspires no confidence. The alternative is pressing forward with the remaining junior attorney, possibly supported by someone from Trump's broader legal orbit. But that means proceeding severely outmatched against experienced federal prosecutors who just achieved a massive psychological victory. Every option is bad. The defense just inflicted what may be the most damaging self-inflicted wound possible in a criminal trial. This episode has sent shockwaves through Trump's inner circle and the legal community at large. According to reporting from multiple outlets, conservative legal circles are divided between those defending the attorney's intensity and those appalled by their lack of professionalism. Online, some Trump supporters insist the ejection proves the trial is rigged and claim the lawyers were removed because they were winning. Others, including conservative lawyers, I honestly wonder how these lawyers, I thought this strategy would work. Help your customers. Fox News legal information. Analyst Jonathan Turley said, defending President Trump's legal position, he looked obviously embarrassed at that time. Discussed the incident. He admitted lawyers can and should, but we will fight with all our might for our customers. Knowingly making a false statement to a judge. If caught, double your bet. Even if it crosses all ethical boundaries, friendly legal commentator, I will do my best to defend my lawyer. Actions that convey how serious it is. It really was. At the same time, legal ethics. The community has come together to denounce that fact. We have arrived. According to the old prosecutor and lawyer speakers from all political backgrounds, found in various stores, career-ending action. These lawyers will almost certainly hit the bar. Complaints can be considered rude. In addition to immediate expulsion, you may face sanctions including fines and fine suspension of their license. Andrew Mr. Wiseman is a former FBI general counsel. Prosecutors said on MSNBC, after decades of practice, he had never seen this before. Something like that. He pointed out that combination of fake statement accusing the prosecutor crimes without evidence and their refusal. A direct order from a judge is usually, the state band will be inverted, potentially criminal contempt procedure. There's more to come. Intense during lunch break, President Trump posts attack on Truth Social individual judge, appellant guerrilla hackers, and their lawyers speak out. They were the heroes who resisted. Corruption. Lawyer. Right away, Trump accused of attacking judge when his lawyer had just been fired. For such behavior, he demonstrated either don't understand or don't care. Following the court crime, former federal judge Nancy Gartner told CNN about Trump's comments. It can be used as evidence that part of it was the lawyer's actions. Thoughtful strategies to create an attractive environment, make a mistake, and cause a miscarriage of justice can really make the situation worse. For all participants and judges, I'll try to find out if that's true. Organized contempt. Let's take a break. Opinions from legal and ethical experts. About this unprecedented moment, the consequences are far more than just bad a day in court. First, immediate questions about how Trump will act. This controversy continues today. According to experienced lawyers are becoming disqualified. Entire legal team prepared during trial. Devastating. Remaining lawyers. There is no command similar to evidence. Cross-check was not prepared. There are no exams. Strategic framework developed within a few months. This puts Trump in a difficult position. The rest are missing test. Some legal analysts told Politico, President Trump should think seriously. Does he want to take a stand? To protect myself now, created by an experienced lawyer, lead your testimony, take risks, increased sense of self-blame. Suddenly, the second one is a bar. Ethical dimension, multi-state panel. The association can launch an investigation regarding the actions of these lawyers. According to Professor of Legal Ethics, Stephen Gillers, made false statements at New York University School of Law. One such application is to apply to the court. Most serious violation. He is a lawyer, told the Washington Post, may be disqualified for less obvious reasons, behavior, and this public personality. This crisis, a clear report. Like I said, defend your actions. It's almost impossible. They can't claim it. There was a misunderstanding or fever momentary error. They specified actual expression so far, immediately refuted, then heated up rather than fixing the situation. Thirdly, there is a criminal lack of respect result. A judge could win on both counts: lawyer for criminal contempt cases, legal proceedings that may result in imprisonment time. That's unusual for a lawyer. According to the old one, crime prosecutors refused direct trial. Order, after being found guilty of contempt, move the situation into this area. You may need to hire your own lawyer, own criminal defense attorney for contempt of court arising from their actions to defend Trump. So, let's see what this means. It's not just two lawyers. I'm having a bad day. It's serious impact of President Trump's immediate legal action situation, overview misconduct of a lawyer in the course of his/her professional duties, and the integrity of the judicial system. First of all, it is the direct impact of the trial. Trump now faces the remainder of his term, litigation through a severely weakened legal system. Team, immediately after accusation, clearly had a devastating effect. After the evidence has been presented and the jury has examined it, lawyers are physically distant falsification trial and throws a tantrum. Legal observers watching over several media outlets were informed in court that may be removed due to incident. No matter what chance Trump has at the chicane, juries tend to reach negative conclusions when a lawyer acts like this. It suggests despair, consciousness of guilt. I'm looking forward to it. Broader implications for Trump. In other cases, this incident may impact. How do lawyers approach representation? Trump is making progress. Competent lawyer will be very indecisive. Once they see what it is, will take back his stuff. You need to make a possible declaration. It cost them their license. According to Reuters, some laws, companies that were considering attorneys in other Trump cases, currently refusing due to concerns about, can they be ethical? Considering President Trump's request, public statement. Qualified reserve lawyers want to represent Trump. As it continues to decrease each time an incident occurs, this, and especially besides Trump, this is a signal to all lawyers regarding the results of supply to customers. Loyalty takes precedence over professionalism, obligation, lawyers and judges. We are closely monitoring President Trump's case. The message sent is clear. You don't lie to the judge. It can't be done baseless accusations, and it can't be done refuse a court order by anyone. How high profile the client or case is, there's more to it than that test. The question is whether it is legal or not. This system works when you have a lawyer, abandon professional standards, scorched earth customer service strategy. Once these lawyers are faced with no, if you can lie, there are serious consequences. Judge accuses prosecutor, if you commit a crime, refuse a direct order, and simply pay the fine or get a slap on the wrist. It's basically called a court. Rules don't really matter to you. Represents a very powerful person. It means we have entered the kingdom. Where is the most offensive and unethical? Legal tactics have become the norm. There are no real disadvantages. That's not the case. Just Trump's lawyers. It is about. Are they all lawyers regardless? Customer status is as follows. Same code of ethics. So, that's the thing. Donald Trump lawyers were physically expelled. Federal court, by sheriffs, after them made a clearly false statement about the judge criticized the prosecutor as follows: providing evidence without evidence and refused a direct order to sit down, please remain silent. It's not just one clash in court. It is about complete collapse of professionalism standards that everyone is expected to follow. Someone who falls into Trump's orbit. Your lawyer wants to be dismissed in court rather than facing the evidence. You tell the jury everything you must know, your strength protection. Once these lawyers are faced with no, we say there will be serious consequences. There are no real rules for lawyers. Influential client representation. Next. The next few days will be decisive. Assets. We have to find a way to end this trial with a destroyed defense team. Expelled lawyers will have to face risks, complaints, and contempt of court cases, and the jury shall decide that I just witnessed this, and what does it mean, reliability of protection. Price. The impact will be greater than ever. I don't have a lawyer, so I won't come again. There will never be a public place and a way forward. Unpredictability for everyone involved. Notice this.